Yes, Mr. Molyneux.
It was John Maynard Keynes who said, when the facts change, I change. But of course that isn't an option which is open to this court in my most respectful submission, because there are very clear findings of fact that lead to the conclusion that the decree which was pronounced in 2013 but was unchallengeable in the period up until the application being made for it to be made absolute by my client, to be rescinded by the wife. We'll look at the findings that the judge came to. But of course, you'll be aware of what the Supreme Court has said in McGrady about the advantages which a trial judge has in relation to hearing evidence and making findings of fact, and how slow appeal courts should be to interfere with the findings that a trial judge comes to. The advantages of seeing witnesses, not only in terms of the demeanour, but also reading, as in this case, many hundreds of pages of WhatsApp and other messages, and reading the statements which were produced and coming to conclusions based on the totality of the evidence which has been heard. Of course, that doesn't form an attack on any of the findings as being perverse or as being unjustified. That doesn't form any of the grounds of appeal. The grounds of appeal are much more focused, much more nuanced, much more legalistic than that. And we say, as we've said in the skeleton, I'm not going to repeat all the arguments which are set out in great detail in the skeleton, why we say that's wrong. But the wife's new test, I'm going to continue, as my learned friend has done, to refer to them as husband and wife. The wife's new test is that in every case on an application for rescission under section 31F, or alternatively on an application for decree nisi to be made absolute, if that application is made by a respondent, the trial judge has to repeat, or the judge to whom the application is made has to repeat the three-stage Owens test, that must start afresh. What are the facts upon which the petition was based? Are they true? Were they true at the time that that was pronounced? What is the subjective effect on the petitioner of the behaviour? That's not identified whether or not that subjective effect is to be revisited at the time, or whether it's to be the subjective effect of that behaviour in the years that follow. And then finally, can the court infer that the subjective effect of the respondent's behaviour is such that she cannot objectively, reasonably be expected to live with him? And if there's any doubt as to how exactly that is put, or whether that is the thrust of the way the wife brings this appeal, it's set out at page 14 of the core bundle, which says in terms...
Which document are you looking at, please?
So page 14, which are the grounds of appeal.
Thank you.
The judge, this is 1B, the judge came up with his own erroneous formulation of a test which required the proposed appellant to prove there had been a marital reconciliation, to have a reference to the judge's own qualitative assessment of the marital relationship. We'll come on to that. Before that, in formulating the test to be applied when considering rescission of decree nisi, he failed to follow the authority of the Supreme Court. And then at C, the judge erroneously introduced a second limb to the test, requiring the proposed appellant to establish, as well as showing the decree nisi was based on unsound findings, that it would be contrary to the interest of justice to rescind that. That he erroneously failed to include in the formulation of the test those factors Parliament intended in cases where the decree nisi is more than 12 months old. And then in application of the incorrect test, which borrows heavily from 2A, in applying his incorrect test, the judge failed to make any assessment of the subjective effect on the proposed appellant of the proposed respondent's behaviour as pleaded in the 2013 petition as the fact under section 1, subsection 2B of the Matrimonial Causes Act. At page 82 in the same bundle, this is learned friend's skeleton, at paragraph 15, that line of attack is repeated. In the majority of divorces, the paragraph starts, the decree nisi is converted into a decree absolute within a relatively short period of time. The petitioner is entitled to apply for decree absolute 6 weeks after the pronouncement of the decree nisi. The court has an ongoing duty to continue its inquiry up to the pronouncement of decree absolute, and events occurring after the pronouncement of decree nisi are capable of being relevant to all stages of inquiry, save for the very first step, which is the primary findings of fact, where the acts pleaded in the petition actually happened. In adultery and behaviour petitions, later events may be relevant to two parts of the evaluative assessment. Firstly, the evaluation of whether the petitioner finds it intolerable to live with the respondent after adultery, or whether the petitioner cannot reasonably be expected to live with the respondent behaviour, and secondly, the ultimate evaluation of whether the marriage has irretrievably broken down. Page 88, again in the same skeleton, paragraph 28, the new test, which we looked at earlier, is set out in greater detail. Drawing the strands together, we submit the test to be applied is correctly formulated as follows: are the primary facts upon which the petition is based true? This is the test which the judge, the trial judge, Mr. Justice Mostyn, ought, my learned friend says, to have undertaken. Are those true? Secondly, what is the subjective effect on the petitioner of the behaviour complained of, namely what happened, presumably, in 2013, not what happened subsequently? And can the court infer, in the light of the assessment of B above, which includes its assessment of the subjective effect of the original behaviour, my emphasis, on the petitioner, in light of all subsequent events, that the subjective effect of the respondent's behaviour on the petitioner is such the petitioner can objectively, reasonably be expected to live with him or her? And arriving at this inference at the rescission hearing, the court's examining whether the original inference made by the court on the pronouncement of decree nisi is still sound in the light of subsequent events. Of course, that test was not before Mr. Justice Mostyn. That wasn't the way that he was invited to approach by Mr. Ewins the issue of whether or not the decree nisi should be rescinded, or alternatively, whether decree absolute should be, whether the decree nisi should be made absolute. Not once was the issue of the wife's subjective response in 2013 and how it fed through into hearing in 2022. Not once was that raised. There was no reference in her statement to the discrete issue of the subjective impact of the 2013 events on her, or the subjective impact of any other subsequent events on her. There were no questions asked about whether or not, given that this is one of the integers of whether or not decree nisi should be rescinded or whether decree absolute should be granted, whether she was telling the truth in relation to what she was saying about the subjective impact in the years that followed 2013 of what had happened in 2013. There was no cross-examination of why and when her attitude changed. There was no detailed cross-examination, because it wasn't relevant on the way that she was putting her case, of, for example, paragraph 12 at page 192 of the bundle, which is her first statement in support of her application. That commences with the words, "Walid pursued a relationship with me despite the hostility between us. Regardless of the toxicity, it was a marriage that endured. I felt unable to leave the relationship, although I tried many times, but each time Walid would repeat how much he loved me and I would go back to him. I've exhibited an exchange between myself and Walid in January 2019. Of course, you won't have that before you. The WhatsApp statements. Forgive me.
The judge, as you remember, we discussed this earlier on, devoted 2 paragraphs to his assessment of the witnesses.
He did.
And how irrelevant all that was. Where are his findings of fact about those matters?
So I'm going to take you through the relevant
No,
paragraphs.
but where does he make findings of fact about the matters that you're now...
Well, he doesn't make findings of fact about those because...
No, but why not?
Because those weren't things that he was invited to make findings about.
But then what was the point of having evidence? What was the point of having statements if you're not going to make any findings of fact, but instead just say, we don't take account of the quality of the evidence?
Well, it would... There are 2 points to that. First of all, it would, in my respectful submission, be unfair to criticise him for not making discrete findings in relation to every issue which is raised. Because there were, for example, 1,000 pages of WhatsApps, which were distilled into 350 pages in a second bundle, and there were a number, 4, I think, possibly 5 witness statements, which had a myriad of allegations and counter-allegations relating to the period between 2014 and 2020. For him to have slavishly followed each of those allegations and made findings in relation to each of them would have been a labour of Hercules. And it wouldn't have been right, in my respectful submission, to expect him to do that. He didn't do that. What he did do was distill the evidence which he heard into conclusions which are set out in meticulous detail in the paragraphs which I will take you to. But I do think, in my respectful submission, that would be an unfair criticism to say, for example, in relation to the paragraph that I have just referenced, that he didn't deal with that discreetly in his judgment. He didn't need to deal with that discreetly. He was able to wrap that up in a series of observations and findings in relation to the quality of the parties' relationship and whether or not it amounted to a reconciliation, which was, of course, at the very heart of the way the wife was presenting her case. I reference this because her case on appeal has now morphed. It's now become, what was I thinking during this period of time? How was I able to deal with Walid's behaviour towards me? And did the subjective impact that it had on me mean that I objectively could have been expected reasonably to continue to live with him? I didn't ask questions, and discrete findings were not made about that issue because that wasn't the way that it was put at first instance. Likewise, if we look at page 158 of the bundle, this is her first statement, paragraph 55. She says there, difficulties in our relationship, as I've mentioned above. Our relationship was often difficult. Walid frequently accused me of having a boyfriend to deflect from his own affairs. These allegations were so upsetting because of the commitment I thought we had that I would block him on WhatsApp for short periods of time. Of course, there was a dispute as to the length of time that he was blocked and unblocked during the course of the 2 days of evidence that the judge heard on these issues. But there were no questions about that, and you can see there she's raising an issue of how upset she was. The subjectivity of that will stand out. That would have been tackled if Mr. Ewens, on behalf of the wife, had been taking the point that is now taken in front of you, and of course it wasn't. So for the judge to be criticised for not having dealt with that subjective element in a discrete part of a discrete test is an unfair criticism, because that wasn't the way that it was canvassed in front of him. It was much more, and we're going to come on and look at Savage, it was a much more of a Savage test, which is were the inferences which were to be drawn from evidence and findings in 2013, were they borne out by subsequent events to mean that the wife couldn't reasonably be expected to live with the husband? A much, much simpler test, and one that I think is broadly, or should be broadly, uncontroversial. We look at page 59, again, just feeding back to the test that is now put before you, my learned friend.
59 of what?
59 of the excuse me, bundle, which is the judgment, paragraph 51. Can I just add in parentheses, Lordship, just in response to the point that you were raising, which was, if I can inelegantly paraphrase it, you hear evidence, then you don't attach weight to the evidence which has been given because of the demeanour of, or because you don't attach weight to the demeanour of the witnesses. You don't think that witness evidence is important. I'd say it's a very inelegant summary of the point that you were drawing out from me. As I read that paragraph, and we'll look at it a little bit later on, but as I read that paragraph, what the judge is saying is that, of course, you can attach weight, appropriate weight, to what witnesses say, but that isn't the end of it. And sometimes you get a better picture, you get a more accurate guide to what has really happened, not by what people say, because people can give evidence in a way that doesn't equate to verisimilitude, has verisimilitude, but doesn't equate to veracity.
Well, he goes further than that, doesn't he? He says, in my judgment, the demeanour of a witness when giving evidence is unlikely to be reliable. A reliable aid, either to finding facts or exercising discretion on uncontested facts.
Which is why he...
First trick in a con man's repertoire.
It can be. It can be. That doesn't mean that it will be in every case. It doesn't mean that you don't attach any weight to any evidence that is given.
Show me where he placed weight in this case.
Well, he repeats what the witnesses have said, and he accepts what the witnesses have said. So he is, in so doing, attaching weight to what they're saying. I'll be taking it out of turn if I do so, but I can take you to the paragraphs.
Take it in your own turn.
Thank you. He attaches significant weight, of course, as he's entitled to documents which you haven't seen today, which are the very, very many pages of WhatsApp and other communications between the parties that illustrated to him the quality or toxicity of the relationship that endured between them. For a relationship falling short of something which should be characterized as a reconciliation, which of course was the test that he was being invited to apply. He says at page 59, paragraph 51, in her evidence to me, the wife accepted that in the period of the marriage before decree nisi, she was the victim of both psychological and physical abuse, but that following the reconciliation, in inverted commas, in November 2014 until the final end of the marriage in March 2020, she no longer suffered physical abuse, but that the psychological abuse continued unrelentingly. That's her evidence. That's evidence that he accepted. Paragraph 52 on page 59, the wife's evidence, the very beginning of that paragraph, the wife's evidence was that the relationship following the reconciliation was toxic and unhealthy. Although it did not include physical violence, she asserted that physical violence apart, they resumed their marriage just as it had been before. Again, accepting the evidence which has been given by the wife, just as he accepts elsewhere evidence that has been given by the husband. Page 47.
So are you saying that the judge found that they resumed their marriage just as it had been before? Are you saying he accepted that evidence?
He did accept that evidence.
Right, so that's a finding that he made.
Yes, I think I'd be hard-pressed to say that he didn't accept that evidence.
Right, so resumed their marriage just as it had been before. Thank you.
Of course, Your Lordship, that I say is supportive of the entitlement that the husband had, the decree nisi to be made absolute, because this was a toxic marriage, toxic relationship, and one that was rightly dispatched, one that was put out of its misery. I think that was the expression the judge used, I can't recall. It led to decree nisi.
Well, that depends on whether the judge, what the judge's task is when he's deciding whether or not to make a decree absolute or to rescind a decree nisi. You'll have to come on to that, because you'll have to fit what the judge did into what you say his approach should have been. But to pick up what is being said by the appellant, it's being said that he, in effect, the beginning and end of the analysis is resume their marriage just as it had been before. That's an answer.
But it's not an answer, because the marriage culminated, we say, in decree nisi. Because of the husband's behaviour, the wife was entitled to that, and because of the impact of the husband's behaviour, the wife was entitled to that. The subjective impact on her and the behaviour itself, facts 1 and 2, led the court to conclude that she could not objectively, reasonably be expected to live with him. If that behaviour continues, if that relationship continues subsequently, then all the more reason for the marriage to be ended by decree absolute. It's not that there was a happy marriage, there was an event, a short period of separation, no findings of fact, nothing to be concluded from it, and then it carries on in the same way. There is an event, decree nisi, pronouncement of decree nisi, a declaration of status in the eyes of the world. That occurs in 2013. If that relationship resumes in its unhappy, miserable, toxic state, that doesn't mean that my argument that there should be decree absolute is thwarted. It bolsters it, in my respectful submission.
I think you'll have to explain that, certainly, because the question is whether the marriage, not any marriage by any analysis, but this marriage had irretrievably broken down. And if the marriage carries on just as it had been before, is there not an argument that it did not, it cannot have irretrievably broken down because it carried on?
No, because in my respectful submission, the relationship may continue. So if it was a relationship of horrible domestic abuse, which culminates with the pronouncement of decree nisi, that horrible domestic abuse continues in the period thereafter. Nobody would dream of saying that that couple should not have their marriage ended, that pronouncement of decree nisi should not progress inexorably to decree absolute.
That's a different question. The question is the marriage. And if you seem to be making the submission that the fact of the decree nisi somehow changes whether it is or isn't a marriage, whether the marriage continues or doesn't continue, whether the marriage has or hasn't irretrievably broken down, because of that. But that's not the question, is it? If a marriage continues, even to give your example, if divorce proceedings nobody had commenced divorce proceedings, the marriage would have continued. It would have remained a marriage, regardless of its flaws or defects.
But it didn't, because of the husband's behaviour. And so it led to decree nisi, and from there on...
You say it didn't. They resumed their marriage just as it had been before.
Well, the relationship continued as it had been before, but the relationship that had entitled the wife to decree nisi similarly entitled the husband to decree absolute. It didn't entitle the wife to rescission of decree nisi, because evidence had been heard and a judicial decision had been made, and a pronouncement of decree to the world had occurred. So we say that to extrapolate that just because things were awful before, that if things continue awfully into the future, that neither of the parties are entitled to a decree absolute would be wrong, in my respectful submission.
Your submission then is that your client in these circumstances was entitled to decree absolute.
I say that he was entitled, on the exercise of the court's discretion, properly exercised, to decree absolute, just as she was entitled to decree absolute had she made a similar application.
At a time of his choosing.
At the time of his choosing.
After however many children.
Well, there was a child who was born after decree nisi.
Yes, there happened to be two, but after 2 children and 9 years, he was entitled to decree absolute.
So he was entitled to decree absolute because the heavy lifting had been done at the decree nisi stage. Thereafter, the marriage, the marital relationship, had ended. There was no reconciliation. There was no putting things back together in a friendly relationship, which is what reconciliation means.
No, it doesn't.
I think reconciliation does. Doesn't it mean actually look this up, in anticipation of this, to become
Are you
friendly?
saying that's the test?
Well, I think reconciliation, the ordinary meaning of reconciliation
No,
is...
you're saying that's the test for this part of your...
So I think that the test is as set out in Savage and as followed by the judge, which is material facts existed at the time of the making of decree nisi but which were not placed before the trial court. That's not relevant here. Or that subsequent events occurred which furnished the clear conclusion that the findings made or inferences drawn by the trial court when making decree nisi were not justified and therefore wrong. And I say that there were no findings in 2013 that were impeachable, and that thereafter the inferences drawn that this wife could not reasonably be expected to live with this husband were borne out.
So isn't there something rather unreal about all this? That what you're saying is that objectively she couldn't reasonably be expected to live with your client. Subjectively, she says that she took a different view, although his behaviour continued in a different way to be unreasonable. How does it work that somebody actually goes on living in that situation? How's that real life?
Well, in the real world, which is why we say that the appellant's approach to this, the actual grounds of appeal, are so divorced from reality. In the real world, the court will use as the key integer of whether or not those inferences drawn by the trial judge at decree nisi stage were accurate as to whether the parties reconcile. That, in the real world, is how courts approach it. And of course, that's why in the real world, that was how Mr. Ewins perfectly reasonably set out his stall for Mr. Justice Mostyn. Because there was no doubt at all that he was inviting the judge to apply the test in Savage. In his skeleton argument, was the original decree nisi pronounced on sound evidence and on sound inferences to be drawn from such evidence? If it was, then it should stand. That's the way that the wife has approached this the whole time. Was there a reconciliation? Plain and simple. We know that because it was in the D11 that commenced proceedings for her. I don't think that's in the bundle. We can provide you with a copy if that's of assistance, but I'll read out what it says. It says, decree nisi, so the wording of the application for the court expressed in these terms. Decree nisi was pronounced on the 15th of November 2013. The parties subsequently reconciled in or around November 2014, with their marriage irretrievably breaking down in or around March 2020. And the box 10 of Form D11, which is the information relied upon, said the reconciliation was the first thing relied upon as justifying rescission. It's my paraphrase. It was the first thing that the wife relied upon was reconciliation between the parties. Her first statement, which we haven't looked at in any great detail, her first statement references the word reconciliation 20 times. It doesn't ever mention the subjective impact of the husband's behaviour on her, which you are now told he was wrong for not having regard to as the second or third limb of the test upon which the wife relies. So in the real world, it just came down to that. Was there a reconciliation or was there not? Of course, there's good reason for why reconciliation would be important.
So just going back, you're saying the judge was told by both parties that the correct test was Savage.
That was what he concluded. That was what Mr. Ewins said.
But I thought you said both parties
Yes.
were saying. Right. So both parties, you say, were saying before the judge that Savage was the right test.
I need to check my notes of what our presentation was. I know that that's right, Mr. Ewins, because I did check.
Because I don't think the judge applied Savage.
I think
That's
the
the
judge...
first point. The second is, just because we asked for them, if you look at the submissions made on behalf of the wife below, I appreciate the word reconciliation was used, of course, but if you look at, for example, paragraph 17, which is on page 5 of that document, it's first referring to, section 1.4 of the Matrimonial Causes Act 93. Court's inquiry is intended to establish the extent to which the basis of the decree nisi may have been undermined, i.e. that the marriage has not broken down irretrievably for the reasons stated in the petition. And then if you look at paragraph 22, well, there's reference also to the provisions of the FPR, in particular the matters set out in Rule 7.32. But then if you go on to paragraph 22, the question for this court must be focused on the facts in relation to this marriage. More specifically, therefore, the question for this court is whether, despite the historic allegations, this marriage, with the quality and attributes it had before it broke down in 2013, was subsequently revived, or did it remain irretrievably broken down, as the court found, etc. And did they reconcile? But that's essentially saying Savage, and as I've understood Ms. Krupel's submissions today, she is advocating for Savage. Now, there might be two elements to it. One might be the unreasonable behaviour element, but there's certainly the other element, the irretrievable breakdown. So there are both elements.
There are.
But the case, just looking at those paragraphs, and please tell me if I've missed other relevant paragraphs, but those paragraphs suggest that what was being advanced, as I see it, was essentially the submissions being advanced today. I appreciate your distinction between there was no reference to subjective and we need to look at Owens in that category, but it's have subsequent events undermined the basis of on which, the decree was pronounced. The decree was pronounced.
Yes.
Because it is one decree.
And one of those might, of course, be, a major one would be if the parties reconciled. Not necessarily lived together, but if they reconciled. And that was the way that Mr. Ewins approached this. You can see, paragraph 8, he says, and again, the judge is criticised for, doesn't borrow the language, but certainly the sentiment. Mr. Ewins says, as is often the case, the root of this application, namely his client's application, is a matter of financial provision. It's unfair to criticise the judge for borrowing from the phraseology which is being adopted on behalf of the wife, as if by so doing he is in some way demeaning or diminishing the case which she's advancing. That is wrong.
It depends if from the reading it appears to be expressed in a pejorative way.
But I hope that I can demonstrate by reference to this document that it's not in any way pejorative. It was borrowing from the approach which Mr. Ewins was placing before him, which is my application is in order to secure more money. And of course he was entitled to do that. I mean, there is a rider to that in relation to the prenuptial agreement and what all of this will mean for the prenuptial agreements, which I will return later. Paragraph 9 on that same page. It is the wife's case. The parties reconciled after the final financial remedies order. It trails off. I think there's a missing word at the end of that. 7 lines down. The reconciliation endured nearly 6 years. Factual issues. The agreed factual issues, the first of them, was whether the parties had reconciled since 2014, and then whether the applicant's adopted son, J, has been treated as a child of the family since he was adopted by the applicant wife in 2015. The whole focus was on this factual issue of reconciliation.
Well, the focus was on, has the marriage continued? Isn't that what reconciliation means? The marriage continues.
I don't think it does. I don't think reconciliation does mean that.
What does it mean?
I mean, I haven't got the OED, but
I think
reconcile is to, forgive me for interrupting.
That's right. Reconciliation doesn't appear anywhere in the statute.
No.
Doesn't appear anywhere in the authorities in any substantive way. The test is you're looking at, you advance savage. So I think it's probably better that we apply savage rather than get over analytical about what words weren't used or were used, because we have to decide whether the judge applied the right test, came to the right conclusion, he came to the wrong conclusion, can we replace it with our conclusion?
So all of the case, I mean, reconciliation, which is the way that he was invited by the wife to approach this case, had the parties reconciled, which has a positive connotation, not a continuation of business as usual, but a positive connotation. Had they restored friendly marital relations after a period of conflict, which had culminated in Decree Nisi. Because it was common ground that they had not lived in the same property, cohabitation, everybody accepted, would not be the right test to apply. But all of the cases, I think all of the cases in the bundle where the courts have considered whether Decree Nisi should be made absolute, involve a period of the parties cohabiting. In more and more, I've done a little table. My learned friend, my junior, has done a little table. More and more, an adultery and cruelty petition from 1892 with 8 years. E&E, 1950, adultery, 8 months. Rose and Rose, adultery, 1957, 8 years and 2 months. Owen and Owen, cruelty, 7 months. Chard and Chard, unclear but at least a year, that's a cruelty petition. And Biggs and Wheatley, adultery, 1 year and 5 months. Savage and Savage, a behaviour petition, 3 years and 8 months. Court and Court, a behaviour petition, 1 year and 2 months. Kim and Morris, adultery petition, 4 years. Of course, the reason why cohabitation is so significant, or reconciliation, to use my shorthand, the reason that's so significant is because it's an objective integer of whether or not the conclusion which was reached, the inference which was drawn at Decree Nisi was correct. Namely that these parties, or that this wife, this petitioner, could not reasonably be expected to live with this husband.
So when you say it has a positive connotation, how positive? Are you looking for, you're not looking for the perfect, whatever that might be, relationship. You're looking for what? Something that's better? Something that's different?
Something that is materially better than the facts which gave rise to Decree Nisi. because otherwise it makes a mockery of decree nisi.
Right, so
Materially better than the
Yes.
what?
Than the facts
that led to
relied
decree
upon
nisi.
to give rise to decree nisi.
So in any application of this type, which happily there are very few,
Very few.
there has to be a full examination into the quality of the marriage.
I think-
Sorry, the quality of the period of time when they live together in the broadest sense of the word after the decree nisi.
and before.
And before, so that it can compare and contrast.
I think there would have to be some consideration of whether or not things in the period post-decree nisi, because after all we're focused on the word of the statute, which is whether or not the petitioner in this case can reasonably be expected to live with. So that's the magic in the
And
living
Sorry,
with.
sorry, just to interrupt you. That's what you're focusing on.
Yeah.
There's the other element, irretrievable breakdown.
Yes.
And and sorry to interrupt you,
Not
but
at all.
you'll need to deal with both, because I really don't see how your materially better fits in with irretrievable breakdown.
So the marriage had irretrievably broken down at all times. To use a necessary but unhappy parallel, if someone is diagnosed with a terminal illness and they rally in the period after that, but the illness with which they're diagnosed gets them in the end, they are terminally ill throughout all of that period.
Sorry, I don't find that an attractive analogy.
But taking it back to marriage, it would seem that on your logic and maybe the judge's logic, people who have a relationship like this couple were never married at all.
Well,
If that's the standard of marriage that you require.
they were married. It just happens that they...
Well, why would they have been married at all? If a relationship of this nature, which was the same after as before decree nisi, is so bad that it can't be considered to be a marriage after, why can it be considered to be a marriage before?
Well, it's because they have the status of marriage conveyed upon them up until that point, and then at decree nisi stage there is a pronouncement.
But why should the law set a different standard for a marriage before and after decree nisi?
Forgive me, could you just pose that to me again?
Yes. Why, if what happens after decree nisi is not worth the name of a marriage, is the same thing before decree nisi worth the name of a marriage?
Because the parties have taken no steps to dissolve that marriage, and until they do so, or until they separate, then they are regarded as being a couple, certainly for the purpose of financial remedy proceedings.
It sounds as if the judge would have said that there was never really a marriage here, because he didn't think much of the quality of the relationship between this couple.
But there is some magic in them taking the step, the wife taking the step of seeking to dissolve the marriage. And of course, up until 1857, it only would have been one stage. She would have been divorced at that point. The purpose of the delay between decree nisi and decree absolute was simply to ensure that if there had been collusion or there had been material facts which hadn't been brought to the attention of the trial judge, because the Victorians were so concerned about the notion of collusion, that people might try and get out of unhappy marriages by lying in order to get a decree. They inserted, I think in 1860,
Yes, but
that
coming
provision.
to the last century rather than the century before, the law was then changed in order to extend the period of time to give the opportunity for reconciliation.
I don't think the purpose was to provide an opportunity for reconciliation. I think the purpose was merely to ensure that the status quo which pertained from the Victorians continued. I mean, in the most...
Isn't it thinking time as well? Isn't it thinking time? In order that you can decide whether you really want to go forward with this. It's not just an opportunity for the Queen's Proctor to
forgive me, you're
go
talking
round and
about the most recent reform.
No, I'm talking about the 1969-70 era, beginning on...
So I don't think that was thinking time. I think that was just a continuation of the status quo which pertained from the 19th century.
There was no policy, you say, in favour of allowing parties to reconcile if they chose to do so before taking the ultimate step to sever their marriage.
Forgive me, I'm just being asked or told something. Yeah, I'm reminded helpfully that when decree nisi and decree absolute were introduced in the 19th century, there was a 6-month period
Yes.
between decree nisi and decree
Yeah,
absolute,
6
and of course that was reduced to 6
Yes.
weeks. So that wouldn't have militated towards more thinking time or desire for more scope for reconciliation. It would have been the opposite of that. So that would be my response to that.
Take that point.
My genius response to that.
Can I just touch on again your assertion that what is necessary is an analysis of the quality of the relationship, which will be very influential on whether or not a decree nisi will ultimately be rescinded. And your submission that although it'll be rare, that such an inquiry will be necessary, because I am extremely concerned about that. The idea that in this day and age, when conduct has disappeared however many decades ago, that we effectively start an examination of people's personal lives in this sort of a way. So, for example, in this case, we understand, in as much as we can look into anyone's marriage, that a key thing for this wife was that before the decree nisi, there had been, and I don't know the details and I don't want to know the details, an incident or incidents of violence which form part of the petition. And that there was no such violence in the period of time they lived together between decree nisi and the final separation. I know you don't accept any of those terms, I'm using them as a shorthand so we understand the chronology. Now, Mr. Justice Mostyn obviously didn't think much of this relationship on any level before or after decree nisi. But could it not be the case that a couple or a wife might feel that she could cope with the downsides of a relationship and was continuing with the marriage, providing there was no physical violence?
Well, if she could, I don't think that would disentitle her from her decree absolute, because she could put up with it. I think that would be, I'd be very hesitant before making that submission to you.
But what I'm saying is that, you know, that could be a complete, from that wife's point of view, she could take the view that she wished the marriage to continue for all its deficits, providing there was no physical violence. I'm not saying that's her case. I'm trying to test with you on what possible basis it's appropriate to start investigating the quality of people's relationships in this way. And where do you put cultural aspects? Do we then have to start having expert evidence about what's culturally appropriate and acceptable or not before we can decide whether or not there's been what you just call a reconciliation, a restoration of friendly relationships?
Now just turn. If we were debating whether or not fault-based divorce or conduct-based divorce should continue, because I understand there doesn't need to be a link between the behaviour and the triple breakdown, then that would be troubling. Of course, we've moved on beyond that.
Well, it's effectively, in a way, being reintroduced, because there's going to this sort of by this close analysis of the quality of the relationship.
Well, I do think there will be now, because either of the parties can insist on a divorce. They could do it on their own application.
Well,
without
on irretrievable breakdown, basically.
Yes, without any recourse to anything else.
But we're not dealing with that, we're dealing with this case.
Well, lady, I understand that.
So you say there needs to be a close inspection of the quality of the relationship, and there has to be established that they'd not just, on whatever terms however they regarded their marriage, resuming that is not sufficient. The judge had to make a finding that they'd restored friendly relationships.
Well, I think the court...
That's my note of your submission.
So the court needed to be satisfied that that the findings made or the inferences drawn by the trial judge when making the decree nisi had been justified. That nothing had happened in the intervening period to give rise to the belief, finding that they were wrong. That was savage. And that was, in fact, the way that the judge approached this case. He acted on a second limb. He didn't get to the second
But
limb.
in deciding what, if anything, may have happened, he did that by a careful analysis of the relationship.
Which he was invited to do by the wife. That's what she wanted, and that's what he did.
It's not just they have to restore a friendly relationship. They have to restore a friendlier relationship, according to the submission that you made a moment ago. It has to be materially better than it had been before decree nisi.
So
I mean, that's the submission.
the judge came to the conclusion, on the pronouncement of decree nisi, that the wife could not reasonably be expected to live with the husband. Did subsequent events demonstrate that inference from the findings that had been made in relation to behaviour and the impact on her, did that stand up? And of course, in order to establish whether or not that stands up or not, whether the wife could reasonably be expected to live with the husband in the period after decree nisi, he had to examine what had happened. That's what he was invited to do, and that's what he did. And the findings that he made, namely that she couldn't possibly be reasonably expected to live with
Where does he say that?
this. So he says,
So your suspicion is the judge found that he could not possibly be expected to live with him.
so paragraph 44, in my judgment, however, there is or should be, this is page 57 of the bundle, in my judgment, however, there is or should be no substantive difference between the test under route A and the test under route C. It would be illogical and irrational if it were otherwise. Under each route, in a structured discretionary exercise, the court will need to be satisfied of the following: that material facts existed at the time of the making of decree nisi, but which were not placed before the trial judge, and or that subsequent events occurred which furnished the clear conclusion that the findings made or inferences drawn by the trial court when making decree nisi were not justified and therefore wrong. So that is savage. 44, paragraph 1. He then goes on to say, and that the degree of error is such to allow the decree to stand would be so contrary to justice of the case that the serious step of setting aside an order made by due process of law is justified. Well, he doesn't engage with that, doesn't need to engage with that because of the subsequent findings which he makes.
I'm sorry, I'm sorry, Mr. Moylan, I'm not following the response to my lady's question. But I thought you said a moment ago that the judge found that your client, that the wife could not possibly be expected to live with your client in the time after decree nisi.
So I was.
That's your submission.
I was just applying the test.
No, because you see, this is to do with the reality check that I was concerned about a moment ago. Does he come out and say that?
So paragraphs 54 and 58 and 60, I'm going to invite you to look at. It's page 60 and 61 of the bundle.
Sorry, 54 first.
So page 60, paragraph 54.
Thank you.
So there are paradoxical aspects to the respective cases. The wife's case is that notwithstanding the terms of her petition verified by her with a statement of truth and found to be true by the court, the decree pronounced was erroneous because she could and did live with the respondent, and it was reasonable to expect her to do so. Further, it was doubly erroneous that the marriage had not irretrievably broken down. Put more simply, she argues that the decree was wrong and contrary to the justice of the case because...
Just stay with the finding for the moment. The wife has said that it wasn't unreasonable to expect me to live with her and with him, and I did.
And paragraph 58, Mr. Ewens relies solely on category 2 facts. It's not part of his case there are any category 1 facts. I cannot say on the evidence that any material category 2 facts subsequently arose, such as to furnish the conclusion that the inferential evaluative findings made by the court that the wife could not reasonably live with the husband and that the marriage had irretrievably broken down were wrong.
Right, so it's paragraph 58.
Thank you.
So the judge is there saying that in circumstances where the wife said she was reasonably able to live with your client, and where she did pursue a relationship, whatever one calls it, with him, the judge reached a decision rejecting that case, paragraph 58. He rejected that case, having found her to be the better witness, and without coming out and explaining why he did so,
Well, I think he does.
What, simply because the relationship was a poor relationship?
Well, I think it goes beyond a poor relationship. It's a relationship consistent with the pronouncement that the wife sought in 2013, which was that the marriage had irretrievably broken down as a result of his behaviour towards her, as a result of which she couldn't reasonably be expected to live with him, and nothing had changed in the intervening period. And of course, he heard a lot of evidence and read a lot of
violence.
evidence.
That had changed. There was no violence. That had changed.
Yes, that was a change, but if things were reversed, and I was trying to make a submission that because there'd been no violence,
I'm not saying that, but you're saying nothing had changed. And I think if you happen to be on the receiving end of domestic abuse, you'd think no violence was a pretty significant change.
I'm absolutely not diminishing that at all, but by the same token, unrelenting psychological abuse would also fall into the category of things that shouldn't happen and things that would entitle someone to pursue a decree nisi to decree absolute, or to have the decree nisi converted into. I'm in no way diminishing domestic violence, and I wouldn't want you to think otherwise. Can I just invite you to look at paragraph 57?
Certainly.
Paragraph 57 on the same page. He says, it's the husband's case, relationship, sorry, this is paragraph 56, it's the husband's case, relationship was just as bad after decrees before. I watched with amazement as Mr. Moylan put to the wife in cross-examination that his own client behaved just as badly, if not worse, after the decrees before it. Again, this was a novel experience for me. My finding on the evidence is that this was always a highly defective marriage. The husband was rightly found to have behaved in such a way that the wife could not reasonably be expected to live with him. On the 17th of October 2013, the date of the certificate, which was formalised on the 15th of November 2013 by pronouncement of decree nisi, the court rightly found the marriage had irretrievably broken down. The parties were drawn back together about 12 months after the making of the decree nisi, but it would be an abuse of language to describe their resumed relationship as a marital reconciliation. While they may have referred to each other into the world as husband and wife, there was no enjoyment of each other's society, no mutual comfort and assistance. They did not, in the words of Lord Stair, derive any solace or satisfaction from their relationship. The treatment of the husband by J as a child of the family with the consequential acceptance of financial liability is very virtuous, but does not, in my judgment, lead me to conclude the resumed relationship constituted a functioning marital reconciliation. And then he then goes on to say, cannot say on the evidence that any material category 2 facts subsequently arose such as to furnish the conclusion that the inferential evaluative findings made by the court that the wife could not reasonably live with the husband and that the marriage had irretrievably broken down were wrong. And then paragraph 60, overleaf. The evidence in this case comes nowhere near to demonstrating that the findings made on the making of decree nisi were wrong, let alone so wrong that to allow the decree to stand would be demonstrably unjust. The evidence shows the parties had a highly defective marriage which was rightly put out of its misery by the making of decree nisi. For reasons that have not been explained, for 12 months after its pronouncement of the decree but before reconciliation, the wife did not apply for the decree nisi awarded in her favour to be made absolute. The delay is very puzzling. In November 14, she and the husband resumed a toxic, damaging, unhealthy relationship which had none of the qualities of marriage and which cannot be described as a marital reconciliation. The relationship endured until March 2020 when it came to a final end. However, I'm completely satisfied that at all times following decree nisi, their marriage was and remained irretrievably broken down. And he did that on the basis of having heard the evidence, the wife's evidence, the husband's evidence, reading the statements that had been produced and trawling through the thick bundle of WhatsApp statements, which I think he references at paragraph 46 of the trial, 51.
You've taken us to those paragraphs, and with respect to them, a lot of them are just statements of propositions. But if you, sorry, I'm finding it difficult to move beyond paragraph 52, and I'm sorry, I keep going back to
No, not at all.
But if you resume your marriage just as it has been before, I struggle to see how somebody else can say that the marriage has irretrievably broken down. If you resume your marriage just as it has been before, you resumed it, whatever the nature, whatever the quality. Now that doesn't mean that you can't later bring a new petition, but I just struggle with how you can square that finding with it's irretrievably broken down.
Because it had irretrievably broken down and it remained irretrievably broken down.
But sorry, that doesn't answer if you resume it just as it had been before.
Well,
forget about the facts of this case. If a marriage resumes, that's why the courts are looking at cohabitation. That's why they're looking at reconciliation. They're all means of looking at whether or not the marriage has or hasn't irretrievably broken down. And if you resume your marriage just as before, is that not wholly contrary to the finding or a conclusion that it's irretrievably broken down?
Could I invite you to look at paragraph 46 on the previous page? This is when the judge is dealing with what is a marriage or isn't a marriage. Of course, he was invited to do this. I'm going to come on to that in a moment. But towards the end of that, he says, it's 5 lines down, in fact, it's true that some marriages degenerate into a toxic relationship of antipathy, resentment, and cruelty. Some time was spent during the hearing discussing the marriage of Martha and George in Who's Afraid of Virginia Woolf. Notwithstanding their appalling mutual loathing, it was a functioning marriage. It was one of those marriages where the spouses can neither live peaceably with each other nor live apart. But no one forms a marriage on that basis. And it's hard to conceive, following a decree nisi, the parties would reconcile on that basis.
Well,
Reconcile
that's a
being
subjective observation. It's
Yes,
not an
what-
analysis of the facts of this case.
Well, he having heard the evidence.
No, but that doesn't deal with his finding that they resumed it. What I'm asking you is, how do you square a finding that parties have resumed their marriage just as it had been before? And sorry, I'm going on about this because in my mind I'm finding it a bit of a block. How does that fit with it has irretrievably broken down?
Because the court has already found that. At decree nisi stage.
Okay.
The court has already determined that
So the
marriage
mere
has-
fact of that's what I was testing you before, the mere fact of the decree nisi changes the nature of the marriage.
It does.
Right.
Absolutely. It's a key event. It's a pronouncement of decree, pronouncement of a decree of divorce.
And that's
For the
what leads to your submission that it has to be a better marriage before than afterwards.
Yes, you have to.
No, the other way around. It has to be better afterwards.
Better
than
afterwards
Yes.
than before.
Yes.
Sorry, thank you.
Because there's already a finding that it's irretrievably broken down. For it to continue in that state can only mean that it continues to be irretrievably broken down. So there needs to be a step change. There needs to be a material improvement, which is why the judge rightly says, although criticised now for doing so, well, he rightly says that you wouldn't contract a marriage on the basis that it's irretrievably broken down.
You'll have to identify when you come to the authorities where that submission is supported by the authorities.
So it's supported by subsection 1 of...
No,
Matrimonial
why it has to be better afterwards than before, and why the mere fact of the decree nisi changes, creates a fundamental line, or distinction, difference. But not now, when you come to the authorities.
So I'm not going to refer to an authority in support of that, but I'm going to refer to the statute, which references at decree nisi stage irretrievable breakdown.
Okay.
Does
So-
paragraph 46 really have any place in a legal judgment? I'm not, in a sense, if it had no impact on the decision, taking issue with judges making observations, but is paragraph 46 anything more than the judge's personal view of things? Has it got any legal content at all?
So I think it does, because he was responding to submissions which were being urged upon him by Mr. Ewins.
Well, I can see that in the days of the ecclesiastical courts, I can see that that the church places certain expectations upon people going into marriage, and no doubt other religions do too. But civil society, I don't think, imposes qualitative.
So in my respectful submission, this is an unfair criticism of the judge, because he was being invited to determine whether or not these parties had reconciled. That was the thing that he was tasked with doing.
Okay.
And he was guarding against any suggestion that he had some romanticized, fictionalized notion of what a marriage should be. It should be happy, it should be sexualized, it should be providing... There's a list of the things that he cautions against. I don't want to paraphrase them, but I will read them. The contract of marriage, this was quoted at him, to him rather, by Mr. Ewins. He references it in his skeleton, along with a number of other authorities which say the same thing. Paragraph 45. I record Mr. Ewins' case. He reminded me that when judging the relationship between the parties, I should keep in mind the marriages come in all shapes and sizes. He cited my own decision, where I stated at 26, the contract of marriage is a very simple one, which does not take a high degree of intelligence to comprehend. It's not marriage status specific, not spouse specific. Whilst capacity to choose and to engage in sexual relations and capacity to marry normally function at an equivalent level, they do not stand and fall together. The one is not conditional on the other. A sexual relationship is not necessary for a valid marriage. The procreation of children is not an end of the institution of marriage. Marriage bestows on the spouses a particular status. It creates a union of mutual and reciprocal expectations, of which the foremost is the enjoyment of each other's society, comfort and assistance. The general end of the institution of marriage is the solace and satisfaction of man and woman. There may be financial consequences to a marriage and following its dissolution, but it's not of the essence of the marriage contract for the spouses to know of, let alone understand those consequences. Although most married couples live together and love one another, this is not the essence of the marriage contract. The wisdom of marriage is irrelevant. That is what Mr. Ewins, on behalf of the wife, was pressing upon the judge. So for him to quote that in his judgment and to remind himself not to fall into the pitfalls of saying, this couple don't seem very happy, and therefore I'm not going to treat that as being a functioning marriage, a functioning reconciliation, would have been wrong. And to criticise him as he has been criticised is, in my respectful submission, very unfair indeed. And that's why he goes on to say, I accept that a marriage may function without cohabitation or a sexual relationship. A functioning marriage does not require the parties to love one another. It does require, however, that the parties recognise they enjoy particular status, and they are in a formal union of mutual and reciprocal expectations, of which the foremost is the sharing of each other's society, comfort and assistance. It is a low threshold, and it is a very measured, if I may say, observation as to what comprises a reconciled relationship, a reconciled marriage. He is not falling into the trap of imposing value judgments any more than judges up and down the country every day impose value judgments. And I would reference cohabitation and the law on cohabitation when it comes to that. I did jot these down earlier. In Mills McCartney and Mills-McCartney, Mr. Justice Bennett, in a line that has garnered much praise subsequently, says, cohabitation moving seamlessly into and beyond marriage normally involves, in my judgment, a mutual commitment by two parties to make their lives together both in emotional and practical terms. It's Justice Williams in IX and IT built on that 2018 case. All England Law Reports 104 at paragraph 68. Whether prior to the formal commencement of marriage, the parties had entered into the sort of partnership involving mutual support, working together, rights and obligations, which may be indistinguishable from those which arise when parties begin to live together only after marriage. That's judges applying their own judgment of what cohabitation means because they are trying to equate cohabitation with marriage. Well, if you've got no signposts telling you what a marriage really is, if you're not allowed to articulate that because that is, in the words of learned friend, the state defining something that the state shouldn't define, then where would we possibly be? There would be all manner of disputes as to when someone was cohabiting and when indeed they separated.
So I think it's rather easy because you have a ceremony. That determines whether you're married.
Absolutely.
Nothing to do with the quality of the relationship. Nothing at all. You don't say, I'm not married because of the quality of my marriage. I'm sorry, that is just a...
But you do say...
nonsense argument.
You
sorry to... But you don't.
I'll take it on the chin.
It's
It's not the worst thing that's ever said to me.
Mr. Molyneux, I was about to say that we have really taken you off your course.
No,
Yes.
I didn't say that you were making that nonsense argument. I say it would be a nonsense argument that I thought I was articulating. So nothing to do with you.
So in case you think that I think that,
Yes.
let me make clear.
I'm going to need a spreadsheet.
Absolutely. It's like subjective and objective. If you think I subjectively think this. Decree nisi, the pronouncement of decree nisi, marks, or would have marked, under the Victorians, the end of the marriage, and should be seen as being a significant landmark in relation to status of a couple. They have to wait for decree absolute, but for a couple, getting decree nisi is a very significant event. They're almost divorced. The marriage is almost at an end. Just as we look at the quality of cohabitation to see whether it's akin to a functioning marriage, we would need, when a decree has been pronounced saying that the marriage is irretrievably broken down, that someone shouldn't be expected to live with someone else because of the way they've behaved, and that it will be made absolute if cause isn't shown within a finite period of time. We should be looking for something in order to get us back on track. so that that can be characterised as being a reconciled relationship. Otherwise, in the context of financial remedy proceedings, marriage just continues until decree absolute. Whereas, of course, we know that in reality, the marriage comes to an end at the point of separation, even though the parties are married. So I don't think it is wrong of the judge. Indeed, I'd go further. I think it was absolutely right, and the thing that he was tasked with doing was to establish whether or not, after decree nisi, pronouncement of decree nisi, and the status that that has, whether or not the parties got things back on track, whether they were reconciled. Of course, this is going, and there's another reason which I have to refer to. There's another reason why the wife would have chosen to present her case in this very specific way. And it's as much to do with money as it is to do with those proceedings, because the terms of the prenuptial agreement identify the duration of the marriage to the point of separation, and thereafter issue of a petition. So, although Moylan and Friend characterise this as, well, if we go back to square one, if this is rescinded and we have a fresh application for divorce, she's then entitled to treat this as being a tenure marriage and is entitled to the provision under the prenup that goes hand in hand with 10 years. That's absolutely not going to be the case, because the prenuptial agreement references separation. The judge has determined that the parties didn't reconcile, and so she's stuck with the date of separation, and there was a petition. And even if she were to overcome all of that, the thinking behind the prenuptial agreement is a relationship, a marital relationship, sharing as a consequence of that, staged payments relating to the length of the shared relationship. So
the wife in paragraph 11 doesn't seem to have reached that conclusion. He seems to have said that the level of provision is increased quite substantially. I mean, it doesn't.
Yeah,
probably doesn't matter for our purposes.
It isn't going to matter for your purposes, but if I can just deal with that. He wasn't addressed specifically, I don't know if you were shown a copy of it, but he wasn't addressed specifically on the terms of the prenuptial agreement or what would flow from it. I think he asked what the additional provision would be.
You wish to keep the possibility of this, in a sense, being if the wife was to succeed in her appeal, it being a Pyrrhic victory, because it wouldn't make any difference.
Absolutely, and I just should flag that out, because it was pointed out by my learned friend that the consequence, the ineluctable consequence of success in relation to this piece of litigation would be a substantial uplift in the amount of provision under the prenuptial agreement, and that doesn't follow. But the other reason that I mentioned it, which is germane to this appeal, is the wife was able to blunt that by inviting the judge to make a finding about reconciliation. Because, of course, if he'd said, yes, you reconciled and you separated in 2020, that was the end of the marriage, then that would have been determinative. Of course, as we stand here now, the only thing that's been determined is that the parties didn't reconcile. So we're left with the date that we had before, unless that fact, that finding of fact, is successfully challenged. And that doesn't form any of the part of learned friend's appeal. We don't have an appeal here on the facts. You're not invited to engage with the jurisprudence on McGrady and McGrady, and to consider how the judge evaluated the evidence which was before him. You haven't looked at the WhatsApps. You haven't, I suspect, haven't read all of the statements in order to gauge how he might have concluded what he concluded. Well, other observation in relation to, forgive me.
No, I mean, just what the judge's analysis appears to be that, I mean, following your submission, that in order for there to be a marital reconciliation, the relationship after what's said to be a reconciliation has to, in some way, be qualitatively different, as you're submitting, from the nature of the marriage before. And he said, absent that, it would be wrong to call what has happened, even though it's a resumed marriage, a marital reconciliation. So he's really applying I don't know where that comes from, some sort of independent test as to what amounts to, or what can qualify as, a marital reconciliation.
Well, my lord, I would say, in my simple way, that that's just common sense. But if there's been a pronouncement saying that the marriage has come to an end and will be put out of its misery in a period of weeks, absent cause being shown why it shouldn't, then something needs to breathe life into it. I mean, at the moment, there is an attempt to reanimate the corpse of this marriage.
I'm not sure that's what he says. He's not saying because of the decree nisi. He's simply saying the quality of the resumed relationship being no better this is not quite how he expresses it, being no better than the quality of the relationship before, it would be an abuse of language to describe that as a marital reconciliation. So he is absolutely, as is being submitted against you, bringing in, and you endorse and promote or advocate for this, a qualitative assessment as to the nature of the marriage.
Otherwise, the decree nisi means nothing at all.
But it means that all those unhappy marriages, they can't reconcile. I mean, a lot of marriages are unhappy marriages. That's the nature of it, and people get on with it. Nobody suggests that they have to get divorced.
But there hasn't been a judicial...
Or still worse, that they're not marriages at all. But
there hasn't been a judicial process which signals
yes,
to the
but
world...
in cases where presumably unhappy marriages are more likely to come to divorce at some stage, those unhappy marriages cannot be revived unless they become, according to a judge somewhere, less unhappy.
But they have the status of being married because they are married. And if they had brought their marriage to an end, or almost to an end, by virtue of decree nisi, and they then wanted to
resume their marriage, they have to do so by consent.
Well, if they wanted to avoid the prospect of decree absolute being made on the back of a decree nisi, then yes. But of course, in the real world, if there is in fact a reconciliation, then that is likely, in that case, if that fictional couple, that fictive couple, actually reconcile, which was the test which the judge was being invited to apply, then decree absolute most likely wouldn't, in the exercise of the discretion, wouldn't be made.
No, they'd have to reconcile in a happier state.
Yes.
According to
Well, assuming that they had had decree nisi pronounced. Decree nisi changes everything.
Changes everything. Yes.
Changes everything. And from that point on, which is why Mr. Ewan's approached it in this way, from that point on, if they are going to avoid decree absolute in the application of one or the other, then they will need to demonstrate that there was a reconciliation. They'll need to demonstrate that it was not reasonable, that it was reasonable to expect them to live together, because that's the finding that the judge has made at decree nisi. I mean, we have to go back to that first principle, which is that a finding has been made by a judge having heard evidence that this lady cannot reasonably be expected to live with this man. All Mr. Justice Mostyn has done is uphold that and say, I've heard all the evidence, I've read all the WhatsApps, and I've come to the conclusion that that's absolutely right. You cannot reasonably be expected to live with this man. And if she wanted to demonstrate that actually she could perfectly reasonably be expected to live with him, that the inferences drawn from the original decree nisi were wrong, then what better way than to show that they actually reconciled, they actually lived together, that their relationship was revived. But she couldn't do that. She tried to, but she couldn't do that. And I should say in relation to the judgment, I know, I ought not, well, I don't think I will need to do this, but I'm going to do it anyway, just to my own peace of mind. I know that you know that in these judgments, not every, I return to a theme I started on earlier on, not every judicial synapse is exposed, not every piece of evidence is recorded. There can be judicial shorthand used. Judges don't have to record all the evidence which they hear. They can be taken to have listened assiduously to the evidence, to have read the papers assiduously, and to have come to their conclusions on the back of that. So just because it's not there doesn't mean that the judge didn't have it in mind. And as I say, if we were to look at the statements in granular detail, and he was criticised for dealing with this in granular detail, even though he was invited to deal with it in that level of detail, we would see that these were two people who were unhappy in the period after 2013 that never reconciled, and that was all in the light of the decree which was granted in 2013, correctly granted in 2013.
In case I forget to ask you later, what do you say to the point about the consequences of if an appeal was allowed?
So if an appeal were allowed, then it would need to be remitted back in order for evidence to be heard, so that the court could conclude whether or not decree absolute should be made or whether decree nisi should be rescinded.
Thank you.
And if it's to be done on the basis of learned friends test, I don't see how anything else could happen, because there's this entirely new subjective element that was never explored at trial, hence the Patalis reference in our skeleton. It was never explored at trial, and it wouldn't be right for the court to impose its own judgment as to what the wife subjectively thought in circumstances in which I haven't had the chance to say that simply isn't true. That's not borne out by the evidence that you gave last time, or the evidence, probably better, the evidence that you're giving this time. So it would need to be referred back. But also, otherwise, especially in the light of the prenuptial agreement, we would have this scenario whereby we have a finding in relation to no reconciliation, which pictures the end of the marriage at a given date, and then arguments about whether or not that should stand, whether it needs to be revisited in the light of a even more granular analysis of quality of the parties' relationship. There is going to be no getting away from an analysis of the quality of this party's relationship in the light of the financial issues that the wife wishes to revisit. And I don't say that in any criticism of her, because of course she's entitled to run her practice in that way. But it's wrong to criticise the judge for having referenced it in circumstances in which Mr. Ewins put it at the very heart of his presentation. Can I just look at Savage?
Of course.
Because
That'd be most helpful, thank you.
so this is page 136. Page 136 of the authorities bundle.
Thank you.
At E, so it's the bottom of the first red-lined extract, draws a distinction between the test that was drawn by the Queen's Proctor, by Mr. Holman. The second main submission was that a stale decree nisi should not be given new life, especially when a prolonged cohabitation had taken place since it was pronounced. The test he proposed was whether the inference drawn by the court originally from the facts of the petitioner cannot reasonably be expected to live with the respondent was still justified in the light of subsequent events. Again, tying that into the notion of cohabitation or reconciliation. Actually, the formulation that was adopted by Wood J goes on to sound quite satisfied at the present time this marriage has irretrievably broken down.
Sorry,
So this is just underneath, paragraph G.
oh, sorry.
Thank you.
I'm quite satisfied that at the present time, this marriage has irretrievably broken down, that the husband has behaved in such a way that his wife cannot reasonably be expected to live with him. But one of the main issues in the exercise of this discretionary jurisdiction is whether the original decree nisi was pronounced upon sound evidence and upon sound inferences to be drawn from such evidence. Final phrase of section 1.2b is too often overlooked. It is an essential factor. So that was the Savage test. The Mostyn test, which I submit borrows heavily from Savage, is found at page 57, paragraph 44.1 of the judgment.
Sorry, I was just still looking at Savage. Sorry, take me back to Justice Mostyn.
Page 57, paragraph 44.1. And you'll see there at page 57, paragraph 44.1, he deals first of all with material facts existing at the time of making decree nisi, which were not placed before the trial court as category 1 facts. with law for present purposes, and or that subsequent events occurred which furnish the clear conclusion that the findings made or inferences drawn by the trial court when making decree nisi were not justified and therefore wrong. So you compare and contrast those two, and there's a distinction without any substantive difference. Wood J says the original decree nisi was pronounced upon sound evidence and upon sound inferences to be drawn from such evidence. Mostyn J says facts which or events occurred which furnish the clear conclusion the findings made or inferences drawn by the trial court when making decree nisi were not justified and therefore wrong. Of course, he then has the second limb of his test, which is attached to the significance of pronouncement of a decree, the status that goes hand in hand with that. It's not intended to be a reversible order. It's a decree nisi until, not decree donec, which I think would be, sorry, it's a decree nisi unless rather than decree donec, which would be until, if my schoolboy Latin is up to it. So he was using the test, reframed in his own words, but it's a tiny textual difference that had been adopted by Wood J in Savage. Again, in defense of the proposition that he was, if this is suggested, treating the wife harshly in terms of the way that he was approaching this, he was mindful, even in the context of reconciliation, not to confuse reconciliation with living together. He didn't borrow from the text of the statute in order to try and import a higher test to say that living together is at the heart of this, and because they didn't live together, then obviously there was no question of her reasonably being expected to live together because the evidence was they didn't live together. He didn't do that. That would have been to set the bar too high. It was what Mr. Justice Parker did in Kim and Morris, and we can see that at page 92 of the authorities bundle. At the bottom of 91. This is a confusing judgment in the sense that the headnote suggests that there was some debate between her and counsel as to whether or not she was exercising a discretion in circumstances in which the parties had lived together for 6 months after decree nisi, relying on an adultery petition. Of course, that was an absolute bar, so the case should probably, insofar as it related to decree nisi and decree absolute, have come to an end there. This additional discussion wasn't necessary, so I suppose strictly it is, as a result, obiter that she would then have moved on to deal with the petition and whether the petition should be dismissed. But she does say, in this context, at bottom of page 91, the wife's case is the husband continued to commit adultery after reconciliation, that she was aware of it since 2008. Nonetheless, she remained reconciled. This seems also to weaken her case insofar as is relevant, which I do not accept that it is, that she was induced into reconciliation on the basis of promises subsequently broken and that the marriage was a sham. I agree with Wood J and Savage that in considering the statutory framework, it's not the task of the judge to assess the quality of the cohabitation, and that in any event it will be an almost impossible task to do so. The old discretion is no longer relevant. I'm not assisted by Moore, by E&E. Delay is in itself relevant, whether not accompanied by cohabitation. It's Justice Payne in Biggs and Wheatley, and Wood J and Savage both stated the length of the delay was a relevant factor. The fact of cohabitation is of central importance, she says, in exercising the discretion. It's not the quality, but the fact. Of course, that would have been a much higher test for this wife seeking a rescission, because the husband would have been able to say, well, we never lived together, we never cohabited, we don't even need to look at the quality, that's the fact of cohabitation. But to blunt the suggestion that the judge was applying tests which were not appropriate for the modern day and for the modern way in which couples live, I can point to that. He was mindful of exactly how this couple had conducted their lives and didn't seek to place a higher bar in order to prevent the wife from running the argument that she wished to run or succeeding on it.
Just, sorry, going back to Savage, because it reminded you about it at the top of page 92. Justice Wood it had been submitted to him that the quality of the cohabitation, so the quality of the relationship, should be examined, and he rejected that.
I think he was looking at the fact of cohabitation rather than the quality of it.
Well, but your submission is quality is relevant.
Well, I'm saying that it'd be much easier, wouldn't it, just to say, did the parties live together? In which case I would be able to, or I would have been able to submit the parties didn't live together, which therefore supports my contention that she couldn't reasonably have been expected to live with him. So therefore, if there was no cohabitation in the period after decree nisi, then that supports my case, and we should not rescind, we should have it made absolute.
What about his rejection of, because you're saying that we should be applying savage, what about his rejection of the need to examine the quality of ... So it's page 137, just below letter B.
Forgive me, could you just repeat that? I was just being asked something.
If you look at 137, just below letter B.
137.
137, sorry, taking you back to savage. In looking at the period of cohabitation, it was argued that the quality of the cohabitation should be examined to see how long the reconciliation continued. I'm not convinced that that is correct.
In view of the wording of many parts of section 2
So
of the
he
Causes Act.
rejects it.
Yes.
So what I was just, because I was reminded by that reading Kim against Morris, you say quality is relevant. So what do you say about that analysis?
So I say that he's putting a higher test. He's saying, if we read on, I'm not convinced that that is the correct approach in view of the wording of many parts of section 2 of the Matrimonial Causes Act. It's also extremely difficult to assess such a test. Although cohabitation would always be with the hope of reconciliation, it's the living together, which is the period which must be examined in my judgment. All the facts which I've mentioned above lead to the inevitable conclusion that the inference originally drawn under the special procedure that the wife could not reasonably expect to live with the husband was the wrong inference looked at in the light of all the circumstances. So I think he's drawing a distinction between cohabitation, which is something which is happier, and living together, which is...
I understand, because he's going back to the wording of 21B.
And also, if cohabitation has happened, then there's no need for the court to delve into its quality. It stands for itself. It's there as a fact.
Can I just be clear about something?
Yeah.
That what you're telling us is that if it was living together, that would be a higher test, and you'd be home and dry, the husband would be home and dry.
Yes.
So any submission or approach that says, well, actually, that living together as a term of art has to be regarded in the modern sense, which often is all sorts of things. It can be 3 nights a week, it can be 2 different households, it can be someone that works on the oil rigs and is away 4 months of the year at a time. It can be many, many things in the modern world. You don't accept that.
So, lady, I'm not going to give evidence myself, but I entirely accept that. I entirely accept the proposition.
So in those circumstances, I'm just not sure how, then on the facts of this case, it would be absolutely inevitable that a court would conclude that this couple were not living together when their relationship in terms of where they spent their time and holidays and so on remained the same before and after decree absolute. But you say they were not living together.
I think that would be a point that I'd be constrained to accept on the... In the way you present it, that would not have been. I think I put it too high, didn't I? Because I presented it as being
well, that was what I was worried about. I just wanted to be clear.
Yeah.
One could say this couple were living together. If various other facts would have to be found, but take for a moment what was said to be the arrangement: 2-3 nights a week, extended holidays. Another child who becomes a child of a family, another child that's born into the family who's a natural child of theirs, all that sort of thing. That could be living together, notwithstanding that it's not 7 days a week under the same roof.
I think I'd be constrained to accept that, yes.
So
it wouldn't, just to backtrack, it wouldn't have been determinative on the facts posited.
Yeah.
On the facts of this case...
Well, on your analysis of the facts of this case.
On my analysis of the facts of this case, it would be different. But I accept that you don't need to spend 7 nights together in order to be considered to be living together.
Just going back to which is the higher test, doesn't that then take us back to what my Lord's just pointed out to in Savage? you don't look at the quality, the fact is whether they're living together. So if you said you're living together, even if it's a toxic marriage or one of those marriages Mr. Justice Mostyn said they can't live together and they can't live apart, would you look at the quality?
So I think you probably have to put that in the context of 1982, which I'm old enough to remember, but not old enough to be an adult.
So am I, but you're too polite to say.
So in 1982, the fact of living together may well have carried more weight than it would now.
But we've just said that living together can mean something very different from what it meant in 1982.
Yeah, so if you were living together in 1982, if you were living in the same house in 1982, which is what that would mean, then that would have some status attached to it, it would have some significance attached to it. Fast forward 41 years, 40 years to last October, and maybe living together doesn't have quite the same significance in a relationship. There would have been far fewer people with the arrangement that we are positing now of seeing themselves as living together, but actually not spending many nights in the same property. I suspect in 1982, and this is obviously anecdotal, I suspect in 1982 that would have been a rare state of affairs.
So scroll forward to 2023.
Yes.
If a judge made a finding that they were living together, in our modern
Yes.
terms, would it still be appropriate for the judge to start examining the quality of that relationship?
It depends what living together means, because of course it can cover a whole host of different scenarios. And if you are, I'd need to revisit the findings as to whether or not he found that they were living together, as opposed to periodically spending some time together, but in the context of what he regarded as being...
Well, he did say that, going back to my Lord's paragraph 52, he did say they resumed the marriage as before, and obviously they were living together before the decree nisi. So I had sort of proceeded on the basis that had an implicit finding, an inferential finding that they were living together, and his problem was the quality of the relationship.
Well, they had sexual relations before, and they continued periodically to have sexual relations...
I wasn't talking about sexual
after.
relations.
No, I understand, but I'm just saying that there are things which mark before and there are things which mark after, and it doesn't mean that the two equate. It just means that some things which were going on before were happening after. The big difference was there was a decree nisi which said that...
I have that point. So just to go back where living together and quality of relationship fit, your submission, and I appreciate I've sort of rather slightly put you on the spot with this, that is that where there is a finding, if there is a finding in any one case of living together, it will depend on the case whether it's appropriate then to examine the quality of the relationship. Is that what you're saying?
So, could you put that to me again? Because
Yes,
I was
of
just
course.
trying to look for a reference.
I'm sorry, do you want to find it?
No, I found it, so
You sure?
forgive me for not paying attention.
No, not at all. I think that you're submitting that if a court finds that the parties are living together, it will depend on the context and the form of living together, or the findings made in relation to the living together, whether a court should then go on to examine the quality of the relationship.
That's correct.
That's how you put it.
That is how I put it.
Thank you, that's very helpful. Now, what reference did you want to take me to?
It was only just to iterate what Mr. Justice Parker said at 92, where she elevated cohabitation above everything else in the context of establishing...
Which was one of the reasons that I said, well, embarked on the living together discussion, which has been most helpful. Thank you. So conversely, it may be that if there's a finding of living together, that may be the end of it. It may not be appropriate, in certain circumstances, it may not be appropriate then to look at the quality of that relationship.
I think you would, it may well now be, I'm reversing from the previous submission, which I just acknowledged. I think it would always be appropriate to look at the quality of the relationship. One of the signposts will be living together. But living together will not be determinative.
Thank you.
Living together is not necessarily a synonym for cohabitation. but is in most cases likely to be.
Thank you.
But the court is going to be looking, given that the marriage has been all but dissolved and the status has been signalled to the world, the court is always going to be looking to see whether or not the inferences drawn prove to be correct inferences. Of course, if the parties have carried on, if the parties have resumed a happy marriage, then it is likely to be that the inference that the wife couldn't reasonably expect to live with the husband has been proven to be wrong. And I think that that's what the authorities effectively say. All of them, culminating in Savage, that is basically the takeaway from those authorities. And that's why I know that I'm repeating myself, so I'm going to stop now.
Well, perhaps we'll stop interfering and let you make
No, not at all. That's why reconciliation was absolutely at the centre of everything that the judge was invited by the wife to do. This idea that he was impermissibly imposing his own view of what a happy marriage was, or what any marriage was. And that really he shouldn't have been doing that at all. He should have been trying to second guess how the wife felt at various points between 2013 and 2022. This subjective element upon which submissions were never made to him, upon which evidence was never given. That's just wrong. And if that's wrong, that's really the appeal as advanced. Because this secondary element which we have been exploring, which is the findings which have been made by the judge, and when he finds that there was no reconciliation, was he actually right to find that? That nowhere appears in anything that you have seen, not the appeal notice, not the first skeleton, not the revised skeleton. That is not the way the case was put. And in answering it now, I answer it on my feet, as you'd expect me to do, but it's absolutely not that which has been telegraphed to us as being how the wife approaches this appeal. Can I just deal with delay?
Of course.
I start by saying, had the parties reconciled, then it would have been open to the two of them to seek the rescission of the decree by consent. And that, you'd imagine, would have been the obvious thing to do in circumstances in which their relationship was back on track and neither of them wished to get divorced. But they chose not to do that. You will know from the papers that that was because there was discord between the two of them, as recorded in the WhatsApp and as evidenced by the statements and discussions about whether there would be a post-nuptial agreement in the event that they did reconcile, and so on and so forth. But the one thing they didn't do, because they spent a lot of time doing that, the one thing they didn't do was make common cause in rescinding the decree nisi by consent, which of course they could have done. In relation to the broader issue about delay, I should just reference Mr. Justice Singer, at page 104 of the authorities bundle. This is the case of S&S, which, as you'll know, dealt with rescission by consent of decree nisi in order to enable the parties to take advantage of the pension sharing legislation which had just been introduced and which, absent rescission of the petition, they would not have been able to avail themselves of. You'll see at paragraph 17 at the bottom of 104, the court's powers to impede decree absolute is clear. Equally clear is the fact that the absence of any application by either of the parties, no power exists for the court to act of its own motion and to make the decree absolute. This is not surprising. There's no obligation on either of the parties to apply for a decree to be made absolute. It's not so difficult to think of good reasons why they might choose to leave their marriage in a state of limbo. A marriage found by the decree nisi to have broken down irretrievably, but a relationship which nevertheless they may prefer not to extinguish. They might contemplate the possibility of reconciliation, the position here. The plans for remarriage of the prime mover for the divorce may fall apart, and the good sense of keeping a live widow or widow's potential pension rights might be a factor, or they may wish to wait for some heralded change in the law which would be to their mutual advantage. Unless, therefore, the court intervenes to delay or halt the process, the limbo period from decree nisi until, if one of them applies for it, decree absolute is within the control of the parties and is indefinitely extendable if that is their joint wish. although Mr. Justice Wood in Savage and Savage found it perhaps surprising that the substantive law does not direct that a decree nisi shall lapse after a given period, possibly 2 years, the fact is that it does not. And of course, I say in addition to that, that had the legislative wished to impose a point at which an application for divorce becomes stale, they had the perfect opportunity to do so when they reformed the law only last year. So it wouldn't, in my very respectful submission, be for this court to impose, through judge-made law, a date at which an application for a conditional order is to be regarded as being presumptively rescindable.
I think we'd find this particular constitution would never be so bold.
I'm absolutely sure of that, but I say it just in case. So that's my response to the point about the staleness of decrees. If the government, if Parliament wished to impose that, then they had the ample opportunity to do that. And there are many, many good reasons why people don't pull the trigger to convert decree nisi into decree absolute. And of course, one of those is the hope of reconciliation. And if you were to drill down into the granular detail, into the dense material which is contained in the WhatsApp bundles and indeed in the statements, you will see that that, of course, was one of the reasons that the husband advanced for not making an application for decree absolute earlier, because he hoped for his evidence, he hoped for the possibility of reconciliation, but on his case, that reconciliation never arrived. Child of the family.
Could we just
Forgive me.
pause on this? Because the judge had said at paragraph 55, we don't have to go to it, but he hadn't encountered a case where an applicant seeks to impeach an earlier decree made in her favour. I appreciate that S&S is a very particular set of circumstances, but that was a case in which there had been a decree nisi, and the husband was perfectly happy for the wife to go back and start again, with a view to them then getting a clean break.
Yes, I wonder whether he's using the word impeach there in the context of criticising the inferences which were drawn from it rather than saying seek to rescind it. Because I'm sure there will have been many cases where a petitioner will have sought to rescind a decree nisi for just the sort of reason that we've been discussing. I mean, by consent, for example. So I hadn't read into
No, I understand.
the use of that word. In relation to child of the family, so the first child who's a child of the family was born after decree nisi, but there's no suggestion that the birth of that child means that the parties were in a marriage which should be treated as being a reconciled marriage for the purpose of this application. I understand that in an appropriate case, on the evidence, the fact that there is a child who is adopted by one party and thereafter treated as being a child of the family might give rise to the conclusion that there had been a reconciliation. But that is just one piece of evidence that the judge had before him in coming to his conclusions. He wasn't obliged, by dint of there being a child of the family, to determine that decree nisi should be rescinded.
The point, as I understood it, is you don't get to be a child of the family without being, except vis-à-vis parties to a marriage.
Well, they were parties to a marriage because decree absolute had not been made. So they were parties to a marriage. So by dint of that, the child would be a child of the family, or be treated as a child of the family. Of course, the husband made that concession because under the prenuptial agreement, there's provision for a child of the family to receive periodical payments as indexed. And he wanted to provide everybody with the comfort that that was something that was going to happen, regardless of the outcome of the litigation, as well as being a concession which is made on the facts. But
So the finding about J is firstly at the bottom of 52. And I'm then looking for the where the judge says that this was commendable or something
Virtuous.
virtuous.
Virtuous, yes.
And that was paragraph, I'm sorry, I've lost it.
Paragraph
57.
57.
Thank you very much.
So it's a slightly odd turn of phrase to refer to husband accepting his financial obligations to a child of the family as very virtuous.
A lady. Let me try and draw these threads together,
Yes.
and then I'll ensure there's nothing that I haven't dealt with that you
No, of
require me
course.
to do.
I'm very conscious that we've asked you many questions
no,
and taken
no,
off course
no.
a number of times, so you must take the opportunity of ensuring that you've got instructions that you've
Thank you.
dealt with all that you wish to deal with.
I should deal briefly with the way that the appeal is in fact formulated, which is in relation to this obligation at all times when brought before the court for the court to apply the three-stage Owens test. Findings on stage one, because I think this is the way that it's put. I know that His Lordship raised this with a friend, but I think this is the way that it's put, that at all material times when it comes before the court has an obligation to check that the three stages are still appropriate, that they're still made out. That first of all, stage one, what happened? Well, that's ordinarily, and in this case, not going to be disputed. Secondly, what was the subjective impact of what happened? And then thirdly, can the parties and the wife objectively, reasonably be expected to live with the husband? Well, stages 1 and 2 are in reality immutable, aren't they? What happened and how she felt about what happened has been determined at the stage of decree nisi. It doesn't then come to be revisited periodically thereafter. Otherwise, the courts would get themselves into all manner of pickle, because you would be trying to work out what the subjective impact of the subsequent behaviour on the wife has been, and thereafter whether she can reasonably objectively be expected to live with the husband. So you could, for example, have a scenario where the parties don't speak to each other, or they do speak to each other and their relationship is demonstrably better. The husband doesn't want to reconcile, and the wife then is perfectly happy because she has this improved relationship. So if it's the subjective response of her to the husband's subsequent improved behaviour, then she wouldn't be able to get decree absolute, because the court would conclude that in the light of her subjective response to his subsequent behaviour, she can reasonably be expected to live with him. Well, that becomes absurd, doesn't it? So we have to have the two immutable items of historical fact: what happened and how did she respond to it? And then a third stage, which is the cross-check to see whether or not, as per Savage, the inference that she couldn't objectively, reasonably be expected to live with him has been made out or undermined by subsequent events. The most obvious one of which would be evidence of the parties reconciling. It's only that third stage, under the Savage test, which we say is susceptible to any form of reconsideration, because it's that inference which is, when made at decree nisi, it's looking to the future. It's an inference as to what is going to happen, as opposed to the first two stages, which deal with a pleading and findings which have been made. And that should be enough to dispatch the bulk of the variously formulated grounds of appeal upon which the wife, in fact, relies. It's not some sort of optional reversibility in relation to decree nisi. It's a finding on a given date that leads to a pronouncement that has a significant impact, as I've said before, in relation to the status of the parties. And it's for that reason, although Mr. Justice Mostyn wasn't constrained to rely on it, because of course his first limb was Savage, His second limb was, does it go against the justice of the case? And of course, this is the bigger picture, isn't it? Which is that in these cases of status, where a pronouncement has been made, where findings have been made, and where it's only really inferences that the court is, it's the bearing out of those inferences subsequently. If this is a reversible decree, then what is the point of it? What is the point of the two stages? I mean, the point of the two stages, as the Victorians were keen to establish, collusion and material facts. And that's why Lordship traced back meticulously, and it's a judgment, if I may say, I don't know whether I'm allowed to say this, or whether it sounds patronising, say not meant to, but it's a judgment of meticulous endeavour and hard work and seriousness. And what he does is he follows that through from the Victorians right up to the present day, and alights upon as the final authority in this sequence the case of Owens, which is proposition for, it's a serious order that has been made, the making of a decree nisi, and that if you're going to go behind that, then you've got to have serious material to go behind it. There is no serious material in this case. Let me end, I think, where I started, which is paragraphs 54, 57, and 60 of the judgment. The wife's case, paragraph 54, page 6. The wife's case is that notwithstanding the terms of her petition verified by her with a statement of truth and found to be true by the court, the decree pronounced was erroneous because she could and did live with the respondent, and it was reasonable to expect her to do so. It was doubly erroneous that the marriage had not irretrievably broken down. That's to be read in conjunction with paragraph 58. I cannot say on the evidence that any material category 2 facts subsequently arose, such as to furnish the conclusion that the inferential evaluative findings made by the court that the wife could not reasonably live with the husband and that the marriage had irretrievably broken down were wrong. It would, in my respectful submission, be a very serious matter to go behind that very clear finding, distilling as it does days of evidence and very significant documentary material, all of which the judge was assiduous in his consideration of. Paragraph 60, he continues, the evidence in this case comes nowhere near to demonstrating that the findings made on the making of decree nisi were wrong, let alone so wrong that to allow the decree to stand would be demonstrably unjust, evidencing that he relied on his first proposition, that he didn't need to rely on his second proposition. The evidence shows the parties had a highly defective marriage which was rightly put out of its misery by the making of decree nisi. Reasons have not been explained for 12 months after the announcement of the decree, but before the reconciliation, the wife did not apply for the decree nisi awarded and her faith made absolute. That delay is very puzzling. He then continues at the end of that paragraph, the relationship endured until March 2020 when it came to a final end. However, I'm completely satisfied that at all times following the decree nisi, their marriage was and remained irretrievably broken down. If you want to know why he came to that conclusion, it's in the rider overleaf. Mr. Ewens describes as my failure to refer to the fact that both before and after the decree nisi there were some positive as well as negative aspects of the relationship. These sporadic occurrences diminished, not a jot, the overwhelming evidence of the toxic, unhealthy, and damaging nature of the relationship. This is not a decree nisi that should be rescinded, because the evaluative findings made when decree nisi was granted have been borne to be completely correct. That this was a marriage that was dead then, has not been resuscitated, and no number of attempts to reanimate its corpse are going to make any difference. The relationship came to an end and continues to be at an end. Can I just make sure that I haven't missed anything?
Take your time.
My lady, that's all I want to say, unless there's anything that I can assist you with or anything that you feel I haven't covered.
Can I just ask a couple of points about paragraph 60, which you took us to
Yes.
again a moment ago? The first one is, we can infer, can we, that looking at 3 lines from the end, the judge considered that there was a marriage up to the time of the decree nisi, and that then following that there was a relationship.
a relationship of sorts.
That's how, if one was, as it were, interrogating the judgment, one would see how he thought it. Obviously, it was a relationship, but it was not a reconciled marriage. Is that a fair way of summarising what is being said there? Because he says that relationship endured until March 2020. 3 lines from the end of 60.
Well, I think what he's referring to is the qualities which he sets out in the previous 2 lines, where he says they resumed a toxic, damaging and unhealthy relationship which had none of the qualities of marriage, which cannot be described as a marital reconciliation. That relationship endured until March 2020. So he is specifically referencing his description of what he has seen from the evidence.
Yeah, so we start with a marriage, we then have a decree nisi, and then we have a relationship but not a reconciliation. The other question on that paragraph is just whether you had any insight into what the judge meant by that delay is very puzzling. In the middle of the paragraph.
I'm sure there will be a germane explanation, but it's not one I'm able to put my hands on. Can I just turn in case I'm missing something very obvious? And if I am, I'm hoping Ms. Carapole is going to...
Well, I think we've asked her, yes.
I'm afraid none of us are able to enlighten you.
Okay.
Thank you very much indeed. Yes, Ms. Curry.
Extremely short points in reply.
Yes.
Firstly, Mr. Molyneux said to my Lord Justice Moylan that a reconciliation means the relationship is materially better than before. I believe, in fact, this is what my lady picked up. It's our fact 3 in our table. There was not violence afterwards, there was violence before. So if that is the test that is urging on the court, it's met by that fact. Secondly, Mr. Molyneux addressed my lady and my lords in relation to the prenuptial agreement. It perhaps doesn't really matter, but I would just like to address that point. It's not a document that's before the court, but the length of the marriage for the purposes of the prenuptial agreement is very carefully drafted as terminating on a separation that's marked by a separation notice, provided that a petition is issued within 6 months. And it seems to me obvious in my submission that a petition that's then dismissed probably wouldn't count for those purposes. It's an argument for another day, and of course the judge on a financial remedies application has a broad discretion. And anyway, the point that my Lord Justice Jackson referred to, the judge himself analysed the difference that would be made if that financial remedies order fell away. The third point I'd like to make is this, is Mr. Molyneux at times during the course of his submissions, he suggested several times that the party's status changed at decree nisi. It did not. The decree nisi does not dispose of the matrimonial cause and the marriage is not terminated. The point is perhaps best illustrated by a question my Lord Justice Jackson posed. My Lord, you said, well, could they only then reconcile by consent? And I think my learned friend, in a circuitous way, said, well, yes, but in my submission, that's much more aptly applied to decree absolute. You can only get married again by consent after a decree absolute, and at times his submissions, I respectfully suggest, strayed into treating the decree nisi as if it had been the absolute, and the status doesn't change until the latter. The final point I'd like to make is in relation to my learned friend's urging on the court to remit this matter for rehearing. He says that the evidence below was not directed to the right question, in effect. Just very briefly, these are the points that I didn't make in response to the Patalis point, but very, very briefly. Firstly, the way that Mr. Ewens framed the question for the judge was, please apply the Savage test, which is the test my learned friend now urges on the court. And that is referred to at paragraph 54 of Mr. Ewens' skeleton. So the evidence was all directed towards that very question. And self-evidently, the wife's evidence, both written and oral, could only be from her subjective perspective. It was only about the subjective effect upon her. My learned friend complains in particular that he was not given the opportunity to cross-examine the wife on when she says the effect of the respondent's behaviour change and how. That's just not right, and I'll give my lady and my lords just the references. Firstly, it was her evidence, and the reference is page 141. This is the when, Walid and I reconciled in or around November 2014, and we remained reconciled for 5 years, eventually separated in March 2020. That is the when, so he was able to cross-examine on that. And as to the how, virtually all the wife's evidence, the how and the why, virtually all the wife's evidence was directed towards those matters. So we see, just by way of example, again, it's the same page reference, page 141, subparagraph D. She explained she was relying on Walid's ongoing emotional and financial support when she adopted J. And further on, and this really ties into that fact 3 I just referred to at pages 150 to 151, she says, Walid said he loved me, I still loved him, I was nervously trying to rebuild my trust, he promised he would never physically assault me again, and he's kept his word. And so it goes on. So the when, the how, and the why was in evidence, and my learned friend was able to, presumably did, I mean, I wasn't there, but was able to cross-examine for sure. So we don't agree that the matter would need to be remitted. Unless there's any other matters in reply that I can assist with, my lady, my lords, that's all I've got to say.
I just ask this, the hearing dates were the 5th, the 6th and the 7th of October, and the judgment is dated the 17th.
I believe so.
I appreciate you weren't there. I should have really have asked Mr. Moylan, but the only 2 witnesses were the parties themselves.
I believe so.
And do we take it that they were both in the witness box for a day or something of that sort?
Mr. Moylan saying he thinks so. I believe so.
It looks a bit like a day each of evidence and some submissions on the 3rd day. Thank you.
Thank you.
Well, thank you both very much indeed, and thank you also your juniors. A special mention ought to go to your junior. I think it's correct, not for any particular reason other than when there's a change of leader. You always have to rely very heavily on the junior, and I'm sure he's been of great assistance to you, so thank you. You won't be surprised, any of you, to hear that we're going to reserve our judgments. I can't tell you precisely when we will get a draft to you as soon as we can, but I make absolutely no promises that I know I will not keep. We will send out drafts in the normal way. For typographical and minor factual errors only, not to re-argue the case, please. May I remind you of the new rules on embargo, which you'll find at the top of the draft. That's very important in all cases, but it's important of cases of this time, which may attract some publicity. And insofar as possible, it's very important for the parties that proper respect is given and that there is nothing is passed on which hasn't reached final approval. I would hope that you can deal with all other matters in writing and agree in order. If not, we'll deal with matters in writing. So thank you all very much, and those sitting behind you, instructing solicitors and junior counsel as well.
Thank you very much.
Thank you very much indeed.
All right.
Yeah.